Honored guests, ladies and gentlemen, it is a great honor for me today to open two events relating to China and economic law. The International Conference, China in International Economic Dispute Resolution, and a special seminar on China in International Economic Law, New Horizons. I would like to welcome you all to the University of Copenhagen, and in particular extend a warm welcome to Ms. Zhang Shujing from the Chinese Embassy and Mr. Erik Laursen from the Danish Ministry of Foreign Affairs. When you, over the next few days, take an in-depth look at China's current policies and their international commitment and investments, I'm pleased to see that the list of speakers and abstracts includes both globally renowned academics and practitioners. At the beginning of 2018, we at the Faculty of Law have launched a new strategy entitled Law for Tomorrow's Society. One of our ambitions is to identify and find solutions to the legal challenges facing our modern society. Solutions that have to be created in cooperation between academics and practitioners. We need to meet across sectors and national borders and work together to find solutions to challenges such as those associated with globalization. Therefore, I'm particularly pleased that the opening of these two events also gives me the opportunity to bid those of you welcome who are new to the University of Copenhagen. Welcome to university, which since 1479 has extended horizons and contributed to moving the world forward by means of intellectual creativity and critical thinking. I'm also pleased that it is here to South Campus that I bid you welcome. Not until the beginning of 2017 did we move to these new premises, and both students and staff are quite pleased with them. Here on South Campus, we share our working day with humanities and theology that we have to thank for the loan of this auditorium. In addition to the improved physical framework, we believe that being part of a larger university environment will promote collaboration between the academic fields. Perhaps it wasn't just a coincidence that in 2017, the University of Copenhagen gained a UNESCO World Heritage Chair for the first time in its long history. Professor Helle Porsdam was appointed. Based on her research across the faculties of humanities and law, she will work to increase the understanding of cultural rights with a view to use these as a common global discourse that can promote inclusive social and political development and mutual understanding of cultures. Having said this, with today's conference in mind, I cannot exclude the idea that there are students and perhaps also researchers that would like to see our new campus area influenced a little more by China. In 2017, the Faculty of Law entered into a cooperation agreement with the Fudan University Law School in China. On the map of Fudan University, I have spotted both basketball and tennis courts, as well as student dormitories. As you probably couldn't avoid noticing when you arrived, the areas surrounding our campus are still under construction, and we have, perhaps not surprising in a Danish context, accorded top priority to bicycle parking spots. I hope you will all bear with the potential noise from the construction site outside today. I look forward to follow our students later this year who use the opportunity provided by our agreement with the Fudan University Law School for student exchange. In November 2017, the Danish Prime Minister Lars Løkke Rasmussen, together with the Chinese Ambassador Deng Ying, dug the first spade of soil at the site of a new facility at the Copenhagen Zoo. It is the site where Denmark's two new pandas will move in at the end of this year. The two pandas are on loan from China and represent a close relationship between Denmark and China. Copenhagen Zoo is looking forward to welcoming the new residents, but the pandas have also created some challenges, not least in relation to procuring the 30 kilos of bamboo that panda bears eat daily. Of this challenge, the keeper in charge of the fodder, Anita Haupt-Holm, has said, "Fresh bamboo shoots can be difficult to obtain in these quantities, even though we have a local bamboo supplier in South Zealand. I have therefore over the last year tested various solutions and got a bit of a breakthrough in my last test, as both panda bears tucked into my bamboo shoots. The solution Anita Haupt-Holm had found, briefly told, is to harvest bamboo shoots in China and freeze them. The discerning pandas are not known for eat anything other than fresh bamboo, So the whole secret lies in the thawing, which must take place at the right pace so the shoes can be served just at the right time. And it is this process Anita Hunt has succeeded in developing. China has a long tradition of providing cute pandas to cement friendships. A more recent initiative is One Road, One Belt, where we are more likely to see China making investments, both at home and abroad, in extensive infrastructure programs. Just as the keeper in Copenhagen Zoo was put to the test by the Panda Exchange, China's increased involvement in the international system also calls for new solutions. At the zoo, it was Anita Hunt that solved the problem of the large amounts of bamboo. With this conference, you are exploring and analyzing the challenges and opportunities which China contributes to the international system, and you thus are providing a constructive contribution to global development. Before I pass on the floor, I would like to thank all those that have made this conference possible. On our side, I would like to especially thank Associate Professor Joanna Jemielniak and Assistant Professor Zhang for taking the initiative and putting in the extensive work needed to realize these two events on China. For the organizing, I thank Maria Lotz and Marina Pagels. I'm also very grateful for Assistant Professor Zhang who has been a great help in organizing these two events in relation to Renmin Law School. In addition, I would like to extend many thanks for the support of the Dreyer Foundation, Think China, the Renmin Law School, and the Transnational Dispute Management Journal as publishing partner. With these words, I yet again welcome you all to the next day's focus on China and economic law. Ms. Shujing and Mr. Erik Laursen will now say a few words about the history and importance of Sino-Danish relations. I thank you very much for your attention, and I wish you a very fruitful conference and seminar the following days. Thank you.
It's my great pleasure to attend today's conference. On behalf of Chinese Embassy, I'd like to extend my sincere thanks to University of Copenhagen for your great efforts to organize today's event. This year is the 40th anniversary of China's reform and opening up. During the period, China has become member of the WTO in 2001. With more and more foreign enterprises coming in and the Chinese enterprises going out, deeply engaged in the international market. Those enterprises benefit from economic globalization and at the same time contribute greatly to China's development and the world economy. According to the statistics from the Ministry of Commerce in China, in 2017, the import and export of China is over $4 trillion, and the direct investments from China has covered 174 countries and regions. This year is the 10th anniversary of China-Denmark Comprehensive Strategic Partnership. China has remained Denmark's largest trading partner in Asia. According to Denmark's statistics, from 2014 to 2017, the bilateral trade is over $10 billion for 4 consecutive years. Chinese investors have shown great interest in Danish market, from shipping, life science, pharmaceutical, green energy to food and agriculture and so on. Most of the investors are private companies creating jobs and tax revenues for the Danish society. Also, the Danish enterprises have shown great enthusiasm to the huge Chinese market. Now, Denmark is the European country with the largest investment in China per capita. It has invested nearly 500 companies in China. Some Danish brands are very famous and welcomed by Chinese consumers, such as Carlsberg, Lego, Echo, and so on. As the bilateral trade and investment deepening and expanding, Air China is planning to open a direct flight from Beijing to Copenhagen in this May. It will further facilitate economic and commercial exchanges between the two countries. Besides active trade and investment activities in each other's market from the two sides, I'm happy to see that since the Belt and Road Initiative was proposed in 2013, Chinese and Danish enterprises from the two countries are cooperating to go to the third market along the Belt and Road. For example, Corvée is working together with China Communications Construction in a tunnel project in Bangladesh. Maersk is cooperating with Chinese companies in port construction in some countries along the Belt and Road. During the process of going out, the Chinese enterprises benefit from the world market. However, because of different laws, cultures, forms of protectionism, and so on, they often encounter various challenges. In recent years, around the world, protectionism is on the rise. However, China will never change its opening up policy. In the 19th Congress of CPC held in Beijing last year, Chinese President Mr. Xi announced that China will only become more and more open. In the coming 15 years, China will have an even larger market. It's estimated that China will import $24 trillion of goods, attract $2 trillion inbound direct investment, and make $2 trillion of outbound investment. This year, China will host the first China International Import Exposition on 5th to 10th November in Shanghai. It's a significant move for the Chinese government to firmly support trade liberalization and economic globalization, actively open its market, and push forward the Belt and Road Initiative. The research on international economic dispute resolution is a very interesting and complicated topic. China and Denmark both benefit from economic globalization and firmly support free trade. As the international trade system encounters new challenges, this topic is of special significance, not only to Chinese and Danish enterprises, but also to the building of a more open and inclusive international economic order and the development of a more just and equitable global governance system. It's highly hoped that all seated here actively share your wisdom and experience. Wish the conference great success. Thank you.
Thank you, Professor Jakob Graff Nielsen, for inviting and for welcoming us today, and good morning, everyone. It's a pleasure to be here this morning as a representative of the Danish Ministry of Foreign Affairs. We all know that China is now the second largest economy of the world, and we also know that China is fastly expected to overtake the US in a few years. China is also the second largest trading partner of the European Union, and the European Union is the biggest trading partner of China. With the economy, investments and trade of that scale and volume, legal disputes are inevitable. This is why this conference on the very topic of China in international economic dispute resolution is so important. When disputes arise, you have to find solutions. To do so, legal and jurisprudential analysis will not stand alone. Business practices, economic facts, cultural differences, and even political perspectives need to be taken into consideration in some cases. Looking at the conference program, it seems to me that such richness of perspectives is exactly the strong point of this conference. Turning to a bilateral point of view, and also mentioned very much by Counsellor Zhang, it is no surprise that China's rapid growth is felt in Danish relations with China also. During the last 10 years or so, total trade between China and Denmark more than doubled, growing from 56 billion Danish kroner to 126 billion Danish kroner in 2016. As a proportion of Danish total trade, this is equivalent to a rise from 3.2 to 5.3%. At the political level too, relations between China and Denmark are closer than ever. Since 2008, China and Denmark engaged in a comprehensive strategic partnership, and that means that we are celebrating the 10th anniversary of this partnership this year. Last year in Beijing, Prime Minister Løkke Rasmussen and Premier Lee concluded a joint work program with 58 specific fields of cooperation between no less than 80 Chinese and Danish government authorities. This, by the way, includes cooperation not just in various fields of economy and business, but also in areas related to law and justice. We hope even closer political ties between China and Denmark may also have a positive impact on business, and we welcome interaction between the business community and our ministers and officials. And in this respect, I would like to draw your attention to the China-Denmark Mixed Committee, which was established as far back as 1980. This committee has made important contributions to business, including resolution of economic disputes, ever since it was established. It is next expected to convene later this year. And before the committee convenes, the Minister for Foreign Affairs, Mr. Samuelsen, will participate in the General Assembly of the Danish-Chinese Business Forum in April. This will provide a useful opportunity for enterprises to give the Minister their inputs. Moving from bilateral to the multilateral level, it is clear that China plays a more decisive role in the world economy and in paving the way for further economic growth, both at home and abroad. This is seen in the Chinese emphasis on a rule-based international order, as well as in the ambitious Belt and Road Initiative. Again, Denmark is an active partner, both as a founding member of the Asian Infrastructure Investment Bank, the AIIB, and also by being present at full ministerial level at the Belt and Road Summit in Beijing in May last year. To conclude, the sheer size of the Chinese economy and the big and high ambitions of the Belt and Road Initiative make it more important than ever to bring together lawyers and other legal practitioners, legal scholars, experts in China studies, businessmen, government officials. And to my mind, this is exactly what you have achieved with this conference. I hope that your proceedings will be of academic importance, of practical use, to the benefit of both academia and business and diplomacy. I wish you all a most successful conference. Thank you.
It is now my great pleasure to welcome our keynote speaker, Professor Vivienne Bath. Professor Bath is a professor of Chinese and International Business Law at University of Sydney and chair of the Research Committee of the China Studies Center, as well as the director of the Center for Asian and Pacific Law. Professor Bath is a globally renowned expert in international economic law with a focus on China, and an author of seminal publications on such topics as foreign investment and dispute resolution law and practice in Asia, the law of international business in Australasia, and the Belt and Road Initiative. It is also worth mentioning that besides holding numerous law degrees, Professor Bath is also a specialist in Chinese literature. It's our great pleasure to welcome you to Copenhagen today.
Thank you very much for that very kind welcome and for the invitation to be in beautiful Copenhagen. It's true it's rather chilly in Copenhagen, but it's certainly a good deal preferable to the 40 degrees, which is currently the average temperature in Sydney. So it's a great pleasure to be here today, and I may say to have the first opportunity to put my views forward, leaving the many learned colleagues in the audience to indignantly rebut them later in the session. What I'm going to talk about today is international economic law dispute resolution in the context of investment law. I will leave to the learned colleagues who are speaking later in this conference to deal with the very important aspects of WTO and trade law dispute resolution. And what caught my eye when I was doing the preparation for this address was a comment in the explanatory notes to the new investor-state arbitration rules, which have been issued by the China International Economic and Trade Arbitration Commission, CETAC, in October of 2017. And one of the reasons given for the issue of these rules was a comment that China has moved from being a bystander in international investment law to being an important participant. And this raised in my mind the question of what this actually means. What was China as a bystander, and what does it mean to say that China is now an important participant in international investment law? As we know, since 1979, when China opened up, China has encouraged foreign investment, and more recently, of course, has very much encouraged Chinese investment abroad in order to further its objectives in developing the Chinese economy. An important aspect of China's policy in relation to international investment law has been the synchronization of investment policy in relation both to inbound investment into China and outbound investment with its approach to international investment law. In fact, China has approached this question in a disciplined manner, which I think is really very enviable in terms of the way in which many countries in the world have approached bilateral investment treaties in particular. This is, of course, coming back to many of the countries, particularly developing countries, which happily signed bilateral investment treaties without really understanding what the implications were or what the implications could be. So if we contrast this to Chinese policy, going back to the opening up in 1979, we see that there has been considerable consistency, in fact uniform consistency, of China's domestic regulatory policies in relation to opening up with its international commitments in its bilateral investment treaties and now its free trade agreements. Similarly, China has been very resistant to pressure in relation to internationalization in changing its policies towards international investment law. Unlike, for example, Australia, which agreed in 2004 under pressure from the United States to move to a negative list approach to investment, that is, approach where it was agreed that all investments would be permitted other than those which were set out on a negative list. China has been very determined to stick to its own policies in relation to the admission of foreign investment. And as I'll go on to mention, this is something which may turn out to be a major issue in its efforts to become a full participant or to be a full participant in international investment law. But another feature of the Chinese approach is that China has been very reluctant to give up control in relation to investment policy. And this is not just inbound investment policy, but unusually in the international sphere, outbound investment policy. So a factor which has had a major effect on Chinese policy in relation to the liberalisation of investment and international investment law generally has been its determination to maintain as much control over investment policy as it could. So we'll have a brief historical excursus, not too long, because I know that I have a time limit as to what I'm allowed to say. But let's have a look going back to 1979 at Chinese policy and then see how it has changed over time in order to examine this proposition that China's moved from being a bystander to being an important participant. And I would say to start with actually that China really has never been a bystander as such. It's been a very active participant even from the early days in relation to bilateral investment treaties. I think with the exception of Germany, China has more bilateral investment treaties than any other country, and many of these date in fact from the 80s and the 90s. Now, these were initially very limited, both in terms of substantive content, which of course is important in terms of dispute resolution, because if you've given very few commitments, there's not very much to actually have a dispute about, but also in terms of dispute resolution provisions. So if we look at the treaties from the 80s and 90s, the dispute resolution provisions, in fact, were limited to the quantum of compensation in the event of expropriation. Expropriation being not very clearly defined, but probably not including too much in the way of indirect expropriation. And many of these treaties, of course, are still around. I checked, and as far as I can see, for example, the treaty with Denmark, which was signed in 1985, is still the binding document between China and Denmark, and its dispute resolution clause is limited again to an arbitral tribunal determining the quantum of compensation. Similarly, the bilateral investment treaty between China and Australia, which was entered into in 1988, has slightly more in the way of substantive commitments, but similarly, dispute resolution is limited in that treaty to compensation for expropriation. Now, China and Australia have, of course, signed a free trade agreement, but the investment chapter there is so minimalist that, in fact, it's still the 1988 treaty which has the effect in terms of a dispute. This policy, of course, changed as time went on. China became a party to ICSID in the 1990s. Towards the end of the 1990s, it started to introduce or to allow the introduction of ICSID, the International Centre for the Settlement of Investment Disputes Arbitration. And after opening up, or after accession to the WTO, China renegotiated several of its agreements with developed countries and entered into more agreements in which it gave more substantive commitments, moving on gradually to the question of most favoured nation and ultimately national treatment for investments, and agreed to a wider scope in terms of what could go through dispute resolution, again using ICSID, dispute resolution. Now, from 2008, China has moved further in terms of what it's prepared to agree to in its treaties. From 2008, China decided to take a more flexible view towards bilateral investment treaties. And what this has meant is that I would call it not just a flexible stage of treaty negotiation, but perhaps an experimental stage in terms of treaty negotiation. And this probably signifies, to my mind, this move in terms of Chinese policy from trying to make sure that it hadn't given too much away in terms of bilateral investment treaties, but also considering what it could gain in the bilateral investment treaty context, and what sort of provisions could be put into bilateral treaties that might in fact be useful. And so the features of the treaties there were first flexibility, in that there are different provisions in the treaties, I think, relating to what other countries were prepared to give, particularly perhaps with developing countries, where the concept of reciprocity and win-win cooperation is important. So, for example, if we look at the China's relations with ASEAN, we'll see that the substantive provisions and the dispute resolution provisions are actually quite narrowly drafted in terms of the sorts of disputes which can be brought between ASEAN countries and China. By the time we get to the China-Australia Free Trade Agreement in 2015, however, which we'll look at in a bit more detail, we can see that China is prepared to be a good deal more experimental and a good deal more flexible in terms of what it agrees to in terms of international dispute resolution. So instead of this fairly rigorous approach towards a model treaty, we see that China is actually looking more widely at the various options which are available to it. Now, an issue that arises here, of course, is the question of China and developing countries. And I won't go into that in very much detail, but that is a question which we'll come back to in relation to the Belt and Road. Because the question is, in relation to developing countries, is China entering into or prepared to enter into a different model in terms of international investment law? Or is it, as some of the African commentators have suggested, adopting the same sort of approach to international investment law that has traditionally been done in bilateral investment treaties. That is China not so much creating a new type of investment treaty or investment obligations, or is it just following along in the traditional model in relation to investment treaties, focusing on protection for investors rather than looking at questions like the environment, sustainability, differential treatment for poorer countries and for different types of groups within poorer countries? Are these things which China is doing in its approach to international investment law? And there are, of course, a number of views on that. As I've mentioned, there's some suggestion that particularly in the earlier treaties with African countries in particular, that China was just following along on the general model. If we go back to our question as to whether China was a bystander or a participant, then we could say that China was perhaps just a bystander, just putting in the usual provisions, although on a reciprocal basis, in these treaties without making any particular allowance for the difficult circumstances or the particular circumstances of the country with which it negotiated. Now, there has actually been a bit of a change there. We see in recent treaties, particularly the treaty with Tanzania, references to the environment and to sustainability. But again, these are fairly brief and they do not really put forward the sort of preferential and differential treatment that some of these countries may have hoped for. Now, what are the recent pressures in terms of international investment law for China? And I'll look into these briefly and then I'll consider some of the effects of China's policies in relation to international investment law and what can be done about them. Now, of course, the big pressure, as I mentioned, is in relation to the question of the negative list. The NAFTA approach, I think we can call it, although we don't know, of course, what's going to happen to NAFTA once the negotiations or the current negotiations are finished. The NAFTA approach to international investment law has been essentially to liberalise investment by having countries compile a list of their essential interests, essentially, which becomes the negative list. Once you've signed the agreement, say with the US, which says that they can invest in everything except for the items on the negative list for which special approval are required, then that list essentially can't be changed. If you give preferences to other countries, then also those preferences should be given to, in this case, the US. Now, the US has had a lot of approach in pushing this, and so you'll see with a lot of the free trade agreements which have been signed in recent years that they do include these negative lists, and they cause a lot of problems. Now, even in Australia, which has one, then you have the issue as to what happens when governmental policy changes. When you no longer wish to sell off your infrastructure, for example, how do you deal with this in terms of the negative list? In terms of ASEAN, it's been very, very difficult to get the ASEAN countries to actually compile their list of reservations, because even within ASEAN, liberalisation of investment only applies to 5 sectors, and ASEAN countries keep on trying to put new things into their lists of reservations in order to give themselves as much flexibility as possible. Now, in 2013, China agreed with the United States in their second attempt to have a bilateral investment treaty with the US that China would go onto a negative list. Now, this was not just a result of US pressure. It was part of China's policy in opening up the economy, from which we've heard from the consul, and it was an effort in part by the Ministry of Commerce and the government to use international negotiations and international best practice in order to force changes within China itself. So we have legislation in China dealing with the negative list, the attempt to move China onto essentially a bifurcated negative list. That is a negative list for foreign investment. Everything would be permitted except for the items on the list, and a negative list within the Chinese economy itself. That is, you won't have to go around and seek numerous approvals for things except for the items which are actually on the negative list. Now, this is, of course, very difficult to accomplish, not just in China, but in any society where the natural tendency of bureaucracy is to add more and more requirements for approvals and permits as they go on. In China, a society where there have always been numerous permits, licenses and approvals required, it's extremely hard to do this. And so what we found is that the big battle for China at the moment is actually putting forward a negative list which is acceptable in the international context. The China-Australia Free Trade Agreement investment chapter relies on the issue of the negative list. Essentially, it relies on the agreement of a negative list between China and the US. The Korean Free Trade Agreement provides for the renegotiation of the investment chapter when the negative list is agreed. The Switzerland Free Trade Agreement also contains a reference to the negative list. So the big challenge generally for China in terms of international investment law and dispute resolution is to actually manage to put forward a negative list which is satisfactory both in the domestic context and in the international context. Now, going back to the question of the issues which have been presented by China's developments in the international investment space, we can see that we've come a long way since the 1980s to the sort of issues which are now being addressed in 2018. But also I think it's true that, as with any other country, the question of your early decisions then becomes more difficult to look at when you come back to examine them. So if we look at the cautious view taken in the earlier bilateral investment treaties, although at the time this would have seemed like the appropriate approach to take to limit the ability of foreign countries to actually take action against China in the event that there was a problem with investment, this is now actually presenting problems for China and Chinese investors. So it's difficult now for Chinese investors to take advantage of these many, many treaties which were signed in the 80s and 90s. It's difficult for investors to take advantage of these treaties if they wish to bring an action against China. So if a Danish company or an Australian company wished actually to bring an investor-state dispute resolution action against China, it would be very difficult due to the presence of these earlier provisions. In fact, if we look at the history of ISDS involving China and Chinese investors, we can see that in some cases we've had Chinese investors actually trying to take advantage of these treaties without very much support from the Chinese state at all. Unlike the attempt by Ping An to take on the government of Belgium in relation to the collapse of Fortis, which failed, where there was strong PRC government support expressed in the Chinese English language press, we can see that some of the earlier attempts to actually use these treaties have not been particularly supported by the Chinese government. Now, the first and most obvious of these, of course, is Tsai Yap-shum in Peru. The complainant in that case was in fact from Hong Kong, although I think he originally came from Fujian. But he relied successfully on the treaty with Peru, and I think somewhat to the discomfort of commentators at that time, he successfully persuaded the tribunal that the clause relating to dispute resolution in the China-Peru treaty, which referred to the quantum of expropriation, also meant that the tribunal could determine whether an expropriation, in this case through punitive taxation measures, had in fact taken place. Now, clearly there are two views on this. I think for many people, you would say that the tribunal can't assess compensation unless it can first determine whether there was an expropriation for which compensation should be paid. The stricter view, which the Peruvian government, of course, pursued, was that the question as to whether there's been an expropriation should be determined perhaps under Peruvian law or in a Peruvian court. And only after that can the tribunal determine under international law rules what the quantum of compensation would be. Now, a similar view has been taken by the arbitral tribunal in the very interesting case of Sanam Investments and Laos, in which Sanam Investments persuaded the tribunal first that the China-Laos treaty included Macau, and Sanam Investments, being a company from Macau, could take advantage of it. And secondly, that the tribunal could determine whether expropriation had taken place. in order to give an award. Now, this has been litigated through the Singapore courts as the site of the arbitration, and the Singapore Court of Appeal, in fact, supported the tribunal on both of these grounds. Now, in relation to I suppose we can say, truly Chinese investors, in this case, Chinese state-owned enterprises, Beijing Urban Construction Group took action against Yemen and was successful on the jurisdictional ground. They also were able to argue that the clause in this case allowed the tribunal to determine whether expropriation had taken place. But in contrast, a recent claim by China Heilongjiang International Economic and Technical Cooperative Corporation, Beijing Shougang Mining and Qinhuang Daoshi Qinlong International Industrial Company against Mongolia failed when the tribunal said that, in fact, no, the clause does not mean the tribunal can actually assess whether expropriation has taken place. In order to assess whether expropriation had taken place, there needed to be a determination by an appropriate authority in Mongolia. And failing that determination, the tribunal could not itself determine that expropriation had taken place and determine compensation. In this case, actually, the Chinese companies have taken action in the US federal court, since the seat of arbitration was New York, in an attempt to have this set aside. So we can see that, in fact, although these treaties looked fairly straightforward on the face of them, even the text of these older treaties is causing particular difficulties. But a very substantial difficulty which is being caused by these treaties now is in relation to the Belt and Road. Now, as we know, the Belt and Road, the One Belt, One Road, extends in a maritime stream down through the South China Sea, not necessarily to Australia, but to New Zealand, and on the continent extends in various directions across to a whole range of different countries. Now, if we go through Central Asia, through the Uzbekistans and all the rest of the stans, Turkmenistan, Kyrgyzstan, Kazakhstan, etc., we see that though in fact there are treaties between China and most of these developing countries along the way, they also date from the 1980s to the 1990s. So if we look at the series of litigation, we can see that in fact the rights of Chinese companies who are aiming to rely on these treaties are severely restricted by the text of the treaties. So although at the time it may have seemed in the 1990s, when there wasn't really very much trade or investment to be looked at, that it was good to have these in place, what the Chinese investors are now finding is that in fact they have very little protection being offered to them by these legacy treaties. So in addition to this, we have the problem that although China has signed quite a significant number of newer treaties with developing countries, a very large number of these are actually not in force. So there are 22 treaties dating from the late 1990s to the present which China signed, which are on better or more international terms, all with developing countries, which have not come into effect for reasons which are not clear. So although China is negotiating free trade agreements and has recently in fact signed up an agreement with Georgia, which is at the end of one branch of the routes going through, it still leaves us with these older treaties with some very, I would say, problematic jurisdictions. So these include countries like Turkmenistan or Kazakhstan or Kyrgyzstan and so on, which have a very large number of outstanding investor-state dispute resolution cases being brought against them, which rank very low on all of the indicators relating to the system of rule of law, and therefore raise the question as to what protection Chinese investors, or other investors in fact, are going to have as they put very substantial amounts of money into construction, infrastructure and other projects as they go along the Belt and Road. And as we can see, this is a problem which is also obvious to Chinese lawyers, officials and other commentators along the way. And we will look very briefly at the sort of steps which are being taken, or some steps which are being taken in order to deal with this problem of the legacy treaties. So if we look at these treaties and we look at China's history in ISDS or investor-state arbitration generally, we can see that there are very few cases. I know that there's going to be a paper which puts forward various views on why there are so few cases against China and by China. I'll take this opportunity as the first speaker to put in a few views of my own on why this should be the case. But one reason, obviously, is this overflow or this large number of legacy treaties under which very few rights are actually given. The Assoc housing case brought by a South Korean company, which failed ultimately on the basis of lack of jurisdiction, was in fact brought under the 2007 agreement between South Korea and China. Older cases, which Ekran, related to development rights to land, was settled, though there is now a new case which has been brought by a German company, Heller Schwarz in China, as to which I was unable to find out the details, which was brought under the 2003 Chinese and German bit. So it's possible, I suppose, that now that new treaties are in place, just as China and Chinese investors have new options to bring actions in relation to the way they're being treated in foreign countries, so foreigners have more potential rights to bring cases against China. So what are the challenges then for China if we look at this overall situation? We've seen that we have the legacy treaties, which may or may not need to be renegotiated. We have the Chinese experimental approach in terms of putting different provisions into treaties, depending on the views and wills of the opposite party, the flexibility being shown by the Chinese negotiators in this relation. And we have the ultimate challenge, which is moving on to the negative list, again sort of following, I suppose, what we would call the NAFTAization of treaties. Now, as we've seen, we have a lot of support at the senior governmental level in China for a program on liberalisation of investors, with what we would have to call the withdrawal of the US from the stage. Essentially, China has come forward as the major and most vocal proponent of globalisation and the liberalisation of investment and investment market access. All of these, of course, have been very kind to China. So in terms of participation in the international investment sphere, there's certainly encouragement at the high levels for, I suppose we could say, for China to step forward in relation to this. In addition, what we've begun to see in Chinese legislation, statements and proclamations over the last 10 years is a higher priority being placed on China's bilateral investment treaties and tax treaties, and the promotion of these treaties as a way in which to actually seek resolution of issues in various problems. That is, although you can also go to your Chinese government department to help you out, increasingly Chinese regulations or Chinese statements, particularly about outbound investment, are urging Chinese companies to take advantage of the options which are being offered in bilateral investment treaties, and thus potentially to increase the number of cases in which Chinese investors are involved. In addition to the cases which I've already mentioned, there is a possibility, I gather, that investors in Mexico or Chinese investors in Mexico are thinking of bringing a further ISDS case. So this may be the beginning of more activity by Chinese companies in relation to their investments around the world. In addition, we have the statement in the forthcoming administrative measures on outbound investment by enterprises, which was issued by the National Development by the NDRC and becomes effective on the 1st of March, which says that the NDRC shall, within the scope of duties prescribed by the State Council, work with other relevant departments to participate in the formulation of international investment rules. So what we are beginning to have is a policy which says that China should be more active in promoting the international investment rules, given its now immense presence in investment in the world generally. In addition to this, we see that China is a very active participant in discussions at an international level dealing with international investment rules. So Working Group 3 in UNCITRAL, which has been tasked with the question of the possible reform of the investor-state arbitration system, has begun its discussions, and it's clear from the first session that China is not just very well informed, but is actively engaged in the discussions in trying to work out whether there is a problem with the current system, and if so, how it should be resolved. Should there be an investment court? Should we continue with bilateral arbitrations? What answers are there potentially in relation to dealing with these issues in the system? And China is certainly very actively involved with this. Similarly, at the domestic level, we see that there have been attempts, well, not attempts, but I should say objurations by the People's Supreme Court to judges and courts to bring themselves up to date in relation to international issues and potential international claims. So in the 2015, several opinions on the provision by the People's Courts of judicial services and safeguards for the construction of the One Belt, One Road. The Supreme Court urges the correct application of international treaties and customs by Chinese courts, the intense study of bilateral and multilateral treaties to which China and the states along the OBOR are parties, including both investment treaties and free trade agreements encompassing investment, and interpretation pursuant to the principles of international law. Judicial support should be provided for, among other things, performance of obligations under investment treaties and free trade agreements. In 2017, in a more recent opinion relating to other issues, this matter came up again. So certainly there is increased consciousness in relation to the question of international investment law. There are also new challenges coming up in relation to the openness of the international investment regime. Some of this can be ascribed to Chinese investment, but I think it's not just Chinese investment which has set it off, because there have also been buying binges, for example, by Brazil, which has come out with considerable amounts of money and has also been making investments. But I think it's fair to say that there's considerable amount of pushback in relation to the whole concept of investment liberalisation. So although I'm going to talk essentially about developed countries in terms of this pushback, we also find it in developing countries which have sometimes found themselves at the wrong side of investor-state arbitration decisions, which have an impact on important things like water, energy, and other policies, or domestic policies. Now, the most significant of these most recently is the question of national security. National security, of course, is a great phrase because you can apply it to just about anything. And I have to say that China is equally, I wouldn't say guilty, but equally involved in this, because at one stage I did a search of the terms of national security in Chinese legislation and discovered that national security can cover just about anything, including national cultural security, national economic security, national defence security. So national security is potentially a very wide-reaching phrase. And increasingly it's being used in relation to foreign investment. So what we see is that China's control or attempts to control things like outbound investment is having an unfortunate, I think you could say, response from other countries, which does affect the question of how much liberalisation there can be in international investment law. In setting up the Made in China 2025 policy, for example, having what other countries are construing as targeted programs of strategic acquisitions of companies which have high levels of technology, particularly dual-use technology. The US and the EU, particularly Germany, I have to say, have become rather not so much suspicious, but unnerved by the amount of the acquisitions of what they consider to be sensitive industries. So even if they have previously been fairly broad-minded about acquisitions, we increasingly find that national security is being called into play in order to try and knock back or to resist some of these acquisitions. So if we look at this, for example, we have had increased domestic legislation in China, Germany, Japan, Italy, the Russian Federation, and the United States in the last year alone. So the US is proposing changes to the legislation governing the Committee on Foreign Investment in the United States. The EU has a proposed regulation involving a framework for looking at foreign acquisitions on an EU basis. Germany has recently announced that it is going to delay approval of an acquisition in high-tech industry. The UK has draft legislation which would tighten up national security review. Australia has recently knocked back a number of acquisitions on national security grounds. And of course we can't forget China here, because even as China has opened up foreign investment by removing a lot of the approvals, it has instituted a national security review system which allows essentially any acquisition to be knocked back on fairly far-reaching national security grounds. So in opposition to the liberalisation of international investment, we're finding that there is considerable resistance. Another issue I think that we need to address in terms of challenges for China as a participant in the international order is the question of enforcement. And I think that this is a little bit of an unresolved issue in terms of investment policy. And the reason I say this is that I think there's likely to be growth in ISDS involving China. As we've seen from the Assoc case and from the Hella Schwartz case, investors are arguably more prepared to actually institute cases. But we also, of course, have the question which has not yet been resolved, which is that we don't know whether China, in fact, would enforce an award which was given against it. Would China be a good citizen, as it has been in relation to the World Trade Organization, and pay up on any such arbitration? Or would it take an approach more like the approach it's taken to the South China Sea and say, well, no, we're not going to do that because we don't agree with the result of the arbitration? Now, there is a line of scholarly approach on which I would certainly appreciate the views of our Chinese colleagues, that there is really no formal mechanism in place in China for the enforcement of ICSID awards. Similarly, because China has an exception to the New York Convention in relation to investor-state arbitrations, it's not clear whether the result of such an investor-state arbitration would be enforceable in China. And of course, there's the issue of China's policy on sovereign immunity, on which, as we know from the Hong Kong case of Hemisphere of Vulture Fund against the Republic of Congo, China takes an absolute view. That is, China takes the view that no award can be enforced against a sovereign state unless it has actually waived immunity. And I think this is going to come up as an issue potentially very soon, because if we assume the Sanlam Investments case goes forward and they win on the merits, what is going to happen when the award comes to Macau to be enforced? As we know from Congo and Hemisphere, Hong Kong and Macau are not entitled to have their own policy in relation to sovereign immunity. There was an interpretation by the NPC after that case which said that very clearly. So we know in relation to the Sanlam case that the Chinese government takes the view that the treaty with Laos does not cover Macau. So in a press conference in 2016, a Chinese foreign ministry official, Hua Chunying, noted that the application of China's investment treaties to the special administrative regions is a question of fact, decided by the Chinese government based on the circumstances and their needs after seeking the views of the governments of the SARs. So if we assume that Sanlam Investments wins its case and then comes to Macau and seeks enforcement, it's going to be a very interesting question, I think, as to whether payment is actually made under that particular treaty, given the views of the Chinese government in relation to this. So we still have this issue, I think, in relation to China and investment dispute resolution as to what approach China will take in the event that an award is made with which China strongly disagrees. There are a number of countries, including, shall I say, Kyrgyzstan, which just do not pay on relation to some of these issues. Now, as I know my time is coming out, I'll look more closely at some of the experimental measures which are coming forward by China. I was talking about China as an experimenter in relation to this question of participation. I think one very interesting thing is the China-Australia Free Trade Agreement, in which the dispute resolution section covers 27 pages as opposed to the substantive provisions which cover only 12 and have yet to be negotiated. Now, obviously, Australia was very reluctant to agree to anything in the light of the Philip Morris arbitration against Australia, which bruised Australia's sensibilities greatly. And so what we have in relation to that particular clause is a clause which gives a lot of power to the sovereign states in relation to what they do. So one country can issue what's called a public welfare notice, saying that a dispute relates to an issue of public welfare, which would then stop the arbitration. The two states can get together to agree on a joint interpretation of the treaty, which is binding upon the arbitral tribunal, again taking a degree of control from the tribunal. And most interestingly, there is a panel of arbitrators to be selected, 5 to be selected by Australia, 5 by China, and 10 to be mutually agreed. And the arbitration will actually be done by 3 of those arbitrators from the panel, when the panel is actually set up and assuming any dispute actually arises. Now, this is a very interesting approach, I think, and it perhaps heralds the CTAC rules, which I'm now going to discuss briefly, in relation to investor-state arbitration. Because what it means is that it's moving away from the more traditional format where essentially you have the same group of generally white men doing all of the arbitrations. Now, I had a look at the arbitrators in the Chinese arbitrations, and in fact, China has a preference for nominating people from that group itself. So particularly New Zealanders and Australians, I'm gratified to say. But if you have a separate arbitration panel for Australia and China, then obviously the constitution of the panel and the arbitral tribunal will be different. It will be much more Asia-focused than potentially the traditional group of European and to some extent American-focused arbitrators. So if we look at the CTAC rules, what the CTAC rules do is they set up a structure for essentially hearing investor-state arbitrations in Beijing or Hong Kong or another location under the CTAC rules. Now, I don't have time to look closely at what's in the rules, but I think what's interesting is the stated purpose of setting them up. And the stated purpose was that there's a gap in Chinese arbitration law because there are no such rules. To this I would point out actually that that's a gap in most people's arbitration rules. It's not something which your average arbitration institution expects to have to undertake. It's a necessary requirement to meet the development of Chinese investment. What they're saying is that ICSID, Stockholm, the ICC, and I would add plus the Permanent Court of Arbitration, all have cases, but there's no provision in Chinese rules. And in fact, if you look at it, that is quite true. I found 520 cases before the ICSID, which of course is based in Washington, 41 cases in Stockholm, 13 cases before the International, the ICC, and 41 cases before the Permanent Court of Arbitration. In fact, if we look at the case which I just referred to, the Mongolian case, it was heard in New York, which is why the application is being made to the federal court. So if you look at it from that point of view, you can see that despite the fact that there are going to be increasing numbers of cases in Asia, it is remarkable that all of the cases seem to be held in other jurisdictions and potentially heard by a different range of arbitrators. So if you look at it from that point of view, the attempt to draw some of that arbitration towards Asia, and particularly China, is certainly justified. The third reason is that it's a way of protecting Chinese enterprises engaging in investments along the way. I haven't found a good English way of describing that, but essentially along the road. And then it says, considering that most of the countries along the road are not perfect and the legal risks are higher, the establishment of investment arbitration rules can provide the institutional guarantee for our enterprises to solve investment disputes with the host countries, protect the legitimate rights and interests of both parties, and serve the construction of all the way. And the fourth reason is that it will further improve the international investment system, in which, as I mentioned before, China is no longer a bystander, but a participant in the development of international investment rules. Now, additional comments by the Deputy Director of CTAC were along the lines that there are cases where Chinese companies were treated unfairly because of a lack of understanding in Chinese law and practices. And we hope China's arbitration rules can help reduce necessary losses along the way. Now, if you look at it more closely, what he says is we're not saying other international arbitration institutes are unfair towards Chinese companies, but there are circumstances where those institutes do not know Chinese law and practice, and that lack of knowledge imposes hardship upon Chinese companies in arbitrations. Now, if we consider the question of these rules, I think there are a number of issues which perhaps are not really addressed in these explanatory notes, and of course these leap out, I think, to those of you who consider them. And the first of these, of course, is that even if you could direct all of the One Belt, One Road arbitrations to Beijing, you still wouldn't resolve the issue of enforcement in the particular jurisdictions. First, because it's only CTAC rules, you would have a question as to whether those arbitral awards could be enforced elsewhere. And of course, you have the question of immunity as to whether those awards would be enforced. This is not an international ICSID treaty that we're talking about. We're just talking about a set of rules. Secondly, of course, you have the problem that the reason Stockholm, for example, has 41 arbitrations is because it is a neutral forum. To have a large number of investor-state arbitrations in China which involve Chinese companies as claimants is not a good look. It would be better really from that point of view, as the rules propose, to have them in Hong Kong or to have them in a jurisdiction which looks more like a neutral venue. So there are, I think, a number of issues which are going to arise in relation to these rules, which is the question of how you're going to get people to agree to have the arbitrations in Beijing, say, or under the CTAC rules. Much will also depend on the panel of arbitrators which are nominated and which agree to serve under these rules. Generally, the rules say that you can't have a sole arbitrator or a majority of arbitrators from the nationality of one of the parties, which should give some degree of neutrality in the arbitration. But, for example, if the parties can't agree on a chairman, then the president of CTAC will appoint the chairman. So there are, I think, issues with this general proposal to the extent that you're going to be expecting to have a large number of Belt and Road claims involving Chinese companies resolved. If, however, CTAC can establish itself as a viable venue for other forms of ISDS or other disputes, particularly involving, say, other Asian countries, then it would achieve the purpose, perhaps, of bringing more of that litigation to Asia, and perhaps opening up a different group of arbitrators and a different group of specialists in this particular area. So in that sense, China's view that it is an important participant would be borne out by this particular proposal. So to go back, I think, to summarise all of the different threads which have come out of this particular discussion, to my mind, it's very clear that China is an active participant in international investment law, and I would really dispute the proposition that it was ever a bystander. It's always been an intelligent and interested participant in what goes on. The question now is the extent to which China, I think, becomes a leader in terms of international investment law. So the CTAC rules are obviously one attempt to establish more of a prominent position in relation to the adjudication of international investment law. The next question, I think, would be the content of free trade agreements and bilateral investment treaties and so on, and whether China can push them into a different and perhaps more acceptable format, particularly to developing countries. As I mentioned with the China-Australia Free Trade Agreement, I think China is in an experimental stage, but nevertheless this preference that China has, or this need that it seems to have for so much control over investment both into China and by its own countries, I think is going to stand in its way in terms of actually really establishing a fully liberalised investment regime. So I'll stop there and open it up for questions.
Professor Bath, thank you so much for this lecture, and please allow me to open the floor for the questions from the audience.
I'm Ole Christian Faukel from the University of Oslo. Thank you so much for a very interesting lecture on this issue. I have a couple of fairly detailed questions, but I hope they would be of general interest anyway. First of all, the Australian-Chinese Free Trade Agreement, the dispute settlement clause concern national treatment. And when you look closer at the national treatment provision, you see that Australia has committed to establishment or admission, while China has not. And I wonder whether you could fill us in on that difference. And moreover, there is no negative list or nor positive list associated with that provision. So it's a fairly broad commitment on part of both. So that's one issue, and then you mentioned the Sanam case, which is a very interesting case. But the first version of that case was settled, and we all know that these settlement agreements are very hard to get hold of. But it's interesting that it was settled in the first round and then it reappears. Would you know anything about that settlement?
I'll start with the China-Australia Free Trade Agreement. The investment chapter in the Free Trade Agreement is actually really quite odd. And I was writing a book chapter on this, so I'm still a bit perplexed as to why the Australian negotiators agreed to it in its present form. As you say, the 27 pages of dispute resolution, in fact, only apply to one provision. And that's the provision relating to national treatment. And as you comment, very unusually, Australia agreed to a non-reciprocal provision. That is that national treatment in like circumstances will be granted in the case of Chinese investments to establishment, acquisition, management, etc., whereas in the case of Australian investments into China, it does not apply to the admission of investments. So Australia has a negative list attached to the agreement, but China does not. Now there's a footnote which says to the MFN clause, which then goes on to say that when China enters into an agreement with a negative list, then Australia will get the benefit of that negative list. And it was anticipated, I think, at the time the treaty was signed, it was finalised really in 2014 and signed in 2015, that the negotiations with the US would go better than they actually did, and that there would pretty soon be a negative list. The China-Korea Free Trade Agreement was signed at very much the same time, and it also has a provision in it which says that within 2 years of the signing, it will all be renegotiated. The investment chapter will be renegotiated on the basis of a negative list, of a pre-establishment negative list. Now, the dispute resolution clause, as you pointed out in chapter, applies only to that national treatment provision. But if you read it, it applies only to investments which have been made. So despite the fact that national treatment is given to admission, the dispute resolution ISDS clause makes quite clear that you can't actually take action against Australia on the basis of the admission of investment. And in case that's not clear, there's a specific exception for decisions made by the Foreign Investment Review Board. So although it looks like a lot's been given, really it hasn't. In terms of the negative list, Australia's negative list is really much the same as the negative list in its other free trade agreements. What China did get out of that agreement was the higher thresholds for investments. So for private investments, it's now much easier to invest in Australia without getting any specific approvals. For state-owned enterprises, where all the big investments have come from, the position is still the same, that you have to go through the approval process. Now, the second question was about Sanam investments, and it's, as you say, it's really difficult to work out what happens in that case. But I think part of the confusion comes from the fact that there are really two cases. So there's one case being brought under the China-Laos Treaty, which is the Sanam Investments case, but there's a case related to the same casino brought under the Dutch bit by a related company. And I think that's the one which had the settlement agreement. They then came back and said, well, actually the Laos government has breached the agreement. They tried in 2015 to open it up again. They succeeded in 2017, and that's now been consolidated into the proceedings under the Laos Treaty. So that's about all I know about the settlement agreement there. But it is a very complicated case.
Thank you. Thank you very much for your excellent speech. It seems you know more about Chinese investment law than I in many ways. Actually, I have no questions for your speech. I just have some information to share with you. From this year, 2018, we begin to implement 2 negative lists towards foreign investment. One is used in the pilot trade zones. Now there are altogether 13 pilot trade zones. As you mentioned, started from 2013. But on the other hand, we have also a negative list which is used in outside these pilot trade zones. So theoretically, we can say China now has begun to use the negative list towards foreign investment in the whole country. But the difference is quite still clear. And in my as I know, the exact number of the negative list used in the pilot trade zone has been reduced to 95 items. But in the national negative list, the number is 384. But anyway, since we have adopted the negative list, the number will be reduced more and more. That's a tendency for the negative list. So this is what I wish to share with you, because this is new information. This is just started from the first day of this month, the national negative list, yes.
Yeah. Yes, thank you very much for that comment. I didn't have time really to go into the very significant improvements which have been made to the investment regime in China. And you're quite right that over a period really since 2013, when the pilot zones were first set up, the government has been working very hard to reduce the number of types of investment which are on the negative list. And I think this really does make investment much easier without having to go through so many processes in order to set things up. The comment I was making in relation to international treaties and the negative list, though, is that certainly to the US, and I think to most other investors, the 95 items and, as you say, the 384 items are still unacceptable in terms of international treaty negotiation. As I mentioned with ASEAN, negotiating these lists is incredibly hard. But if you look at the sort of lists which the US puts up or Australia puts up or other countries put up, then they're considerably shorter than the number of items. So I think the battle for China is to deal with the internal concerns and worries and considerations in order to get the negative list into a shape which is going to be considered to be acceptable in the international sphere.
And as we have a space for the final question, I would like to ask the final question myself. You have mentioned in your speech the active part that China is actually taking in the ancestral discussions related to the scope of the possible reform of the ISDS, and especially in the context of the ongoing dispute about the dispute resolution mechanism for the Belt and Road controversies and this probable or very likely influx of new types of cases coming from this initiative. What is your opinion on the possible China's support for the establishment of the multilateral investment court or permanent adjudicatory body for investment disputes?
I don't think I can really comment on that because all that's available at the moment is a 5-day audio recording of the 5 days proceedings, and I have to admit that I haven't had the opportunity to sit down and listen to the 5 days. And also I think that group is really not at the stage yet of making any sort of thing that resembles a recommendation. I think it took them 1 day to appoint the chair of the session, as far as I can make out. They weren't able to agree on the report of what happened, so it still hasn't been issued. So I think that really, as far as I can make out, most of the time was spent looking at discussions and proceedings and how they should go ahead to discuss whether you'd need whether you should just go ahead on the bilateral basis or set up a court, or whether there was any problem in the first place. So I think it's probably too soon to actually make a comment on that, but perhaps one of our Chinese colleagues would have a view on what China's view is on an international court.
Perhaps more comments will come during the investment session. And for now, I would like to thank very warmly the speakers of our opening panel. And I would like to thank very much the audience as once again. Welcome everybody to Copenhagen and to our conference. And I would like to conclude our session. And during all the breaks, the coffee and refreshments will be served in the canteen of the theology department, which is behind the glass doors. Thank you so much.